NACDL is the association of the nation's criminal defense bar.
Today we're going to talk about social media monitoring of various flavors and obviously the impact on criminal defendants and the public at large. And hopefully we'll also get to talk about a few ways forward for all of us to sort of learn more about this, but also impose more restrictions on this government practice.
And I should add before we get started, we were supposed to have a third speaker, but he has issues with, I guess his partner has some issues, so he's not available. So we'll actually be able to have, I think, a little bit more time for questions too. So think of things you guys want to ask, and hopefully we'll have some time set aside for that too. And I'm Hanni. I'm with the Federal Public Defender in Oakland.
And our other speaker was going to be Stephen Renderos, who's with the Center for Media Justice. The Center for Media Justice has been an amazing partner on a lot of work that the ACLU has done around racial justice issues, and specifically on social media surveillance. So y'all should look into their work and their latest work vis-a-vis Facebook. So we first, I think, need to lay out what we mean when we talk about social media surveillance. There's a few different types. One of the most common forms that all of you are familiar with is going to be your formal legal demands to the companies. So this will be subpoenas and warrants. These have to meet legal standards, obviously, and some of these are going to be vetted by judges, and these are going to go into the social media providers, and they're going to hand over content, non-content, potentially location data. We've all seen this in criminal cases before, but today I think we want to also expand the map, and I specifically do because a lot of my work is looking at social media surveillance that happens outside of the formal legal process. And this is probably the type of surveillance that some of you have seen in your own cases. So there's at least 3 different types that I'd like to sort of outline, and then if folks have questions about particular providers or particular techniques, we're happy to follow up and answer those later on. So, the first one makes sense to a lot of people. It would be the sort of ad hoc access by law enforcement officers or agents or investigators to social media accounts. This can take the form, and it frequently takes the form of the use of undercover accounts on social media platforms. We know this practice is really widespread. Recently, Kashmir Hill at Gizmodo did a series of public records requests to dozens and dozens of law enforcement agencies. Of the ones that answered, many had a practice of looking at social media with undercover accounts. Only, I think, about a quarter actually had policies that could be construed as actually regulating this practice. So policies that would require a justification for creating an account, some sort of exhaustion requirement to show that the undercover account was a sort of last resort before legal process, or having any sort of transparency. This is like totally lacking in this space. It's a highly unregulated space. I'm confident that many of you have seen information come up in your own cases that's been attributed to informants that it was likely obtained by undercover law enforcement accounts on social media. It's not just that this practice is really unregulated. It's frequently, like so many surveillance tactics, disproportionately going to impact people of color, activists, people who are speaking, critically of government authority, folks who are part of Facebook groups potentially who are doing political activism or organizing. And what happens, and this is actually something that Stephen has said, is that you have often, and frequently I would say, years-long sort of social media dragnets of undercover accounts that exist and that establish a bunch of digital tripwires for persons online, waiting for them to post that first thing that could be construed as, violating some statute. I was actually just on the phone yesterday with the defense attorney in Santa Clara County, and he told me that he had a client last fall who had posted a photo of a public case file on Instagram, and in the comment he had added to the post was indirectly, could be understood as, referring to somebody as a snitch. It didn't call out the person by name, it didn't tag the person. Others in this person's feed and his followers, interacted with the post, And this person was charged with witness dissuasion, which in California, as I understand it, is a felony. Because others had interacted with the posts and, not even considering this person's past history, this person was also charged with a gang enhancement on top of the witness dissuasion. As the public defender told it to me, that would have potentially carried 7 to life in prison, simply because they posted on social media and were in a space where they were interacting with others and were, they were a person of color and they could be charged with this sort of crime. The DA also contended that those who had reposted this post could potentially be running afoul of the sort of witness dissuasion statute, which does not require that the dissuading, be the witness against you yourself. The DA didn't bring those charges, as I understand it, and the judge ultimately lowered that to a misdemeanor. But I think that really underscores the sort of the gravity of what it means for law enforcement to be creating these online accounts, maintaining this presence on social networks. And the social networks have not, I know this isn't a social network conference, and I'm not sure if anyone is from Facebook or Google here, but they have not done a good job of actually communicating their policy of saying, actually, law enforcement, government agents shouldn't have accounts on these services. It wasn't until a few months ago that Facebook actually changed their law enforcement guidelines to clearly communicate, of course this is hard to enforce, but to clearly communicate that law enforcement shouldn't have undercover accounts on the service. Facebook also has done a lot to enforce its quote-unquote real names policy, but it has done that mostly vis-a-vis transgender people who don't have an ID that reflects their name that they use in real life, or survivors of domestic abuse who are using a pseudonym on the service to stay safe. Facebook's enforcement of their names policy, which is fraught and is very difficult, and it's hard to know who's behind an account, obviously, has been disproportionately targeted at non-government users. This has only become more obvious in light of the sort of Russian influence operations and all of this. And as a practical matter, it is difficult in many cases for Facebook to know who is behind these accounts, but they haven't done themselves any favors and they haven't done defendants any favors by prioritizing enforcement against non-government actors. So I also want to talk about a sort of second flavor of social media surveillance. This is one that's assisted by software products. There's an entire industry out there. Many of you have seen product names like Geophilia, like Babel Street, like X1 Social Discovery. There's dozens and dozens of products out there that purport to provide a surveillance sort of package for law enforcement, for governments. What these services frequently do is they'll pull together posts in a very searchable, navigable, and very accessible sort of, Google Maps sort of view of a particular area where posts from different networks are surfaced. The users of these software products can go back in time frequently, which is pretty difficult if you've tried to search back in time on a Facebook or a Twitter page. And they allow for, alerts to be set around hashtags, around users, so that when a particular user handle speaks up on a network, they might get a text message, things that, the social networks themselves don't offer to most users, or at least not Facebook. And these services frequently cost way less than your traditional surveillance software, or your traditional surveillance equipment, I should say. Things like Stingrays cost $250,000 a few years ago. 1-year subscription to Geophilia, often you're going to get a trial if you're in law enforcement. For 3 months, you might get it for free, and then after that, it's going to be really cheap. So the friction of actually deploying these technologies is pretty low, and it doesn't frequently require that law enforcement go to the city council, go to the board of supervisors, and seek legislative, fiscal approval for these technologies. I first heard about these technologies like 4 years ago or so when I heard from a chapter member of ours in Fresno, and they said that the police chief there in Fresno was bragging about the use of social media surveillance tools, like something that allowed him to be able to look at social media in a new way. We hadn't really ever heard of this before, so we filed a public records request. And it turned out that Fresno, which is not, the biggest police department, it's not the most sophisticated police department in the state, and it's not the most well-staffed police department in the state. They had been using at least 3 different products for social media surveillance, including this one called Geophilia. But one of the most interesting ones was it was called Beware, And what this product did is it purported to take social media data, data broker data, which might include public records data, and data from other third-party sources. And it provided a threat level indicator to law enforcement who would give the name of the person they were about to interact with into the software. And the software would kick back a threat level color. It's like the DHS threat level system, but even worse in some ways. And it would then be information that law enforcement would potentially use in interactions with the public. So you have law enforcement with guns about to interact with people on potentially inaccurate information. We revealed these records, and at a public meeting, a city council meeting, the city council member actually asked the police, like, run my address through it, like, tell me what my threat color is. And this council member had never been arrested, and they were yellow. They were yellow because the information from the public records data broker that this company had obtained it from likely was out of date or inaccurate and had an address associated with somebody else. Fresno walked away from that product, but that's just, that company, still continued to market it to other law enforcement agencies for really pennies on the dollar. We knew that if Fresno had these sorts of tools, that it was likely other law enforcement agencies did. So the ACLU, we did over 60 different law enforcement agencies in the state. We sent public records requests. The Brennan Center also did a really great survey of different agencies across the United States. And we found in around 2016 that these software products were very widespread. There had been a demand for a long time, as we all know, for law enforcement agencies from them to get at this information, and a market had emerged to sort of serve this demand. One of the products was called Media Sonar, and in the marketing materials for this product, there was a suggestion of hashtags that law enforcement agencies should be searching. Some of those hashtags, one category of those hashtags were Mike Brown related. Those included hashtags which were to be treated as public safety threats. The hashtags of Black Lives Matter, We Want Justice, Hands Up, I Am Unarmed was a hashtag that was flagged as a public safety threat. And these were marketing materials that were being passed down to police departments across the United States for a product running on an opaque algorithm that the public didn't have access to, that many law enforcement agencies could just roll out without hardly flipping a switch. Another product was called Geophedia, and this product had marketing materials that labeled unions and activists as public safety threats, also provided a really user-friendly product for searching and following people not suspected of any crime, and then receiving updates about those people. In these product materials, we noticed there was some bragging about sort of privileged access to data at the social networks. They said they had fire hose access to Facebook and Instagram and Twitter data, and they seemed to be accessing data that you and I wouldn't be able to access unless we had a developer deal with one of these companies. So we got Facebook and Twitter on the phone, and we said, it sounds like law enforcement, or there's a company out there selling this product who says they have pretty uninhibited access to many posts on the networks. And they said, well, let us get back to you. And then they got back to us, and they're like, oh yeah, these companies have API access to some of our public APIs, and they are, violating our terms, and we're going to cut them off. But, we didn't know about this, and this is something that we don't want on our platforms. And it just became very evident to us that the social networks had no idea what was going on, and they were doing very little to audit their developer relationships, which is obviously something that came to the fore earlier this year with the Cambridge Analytica fiasco. These companies were getting the data through similar means, but they were actually going in a way that went outside of the user's view altogether. You might remember with Cambridge Analytica, a lot of that data was pilfered from people taking quizzes. There was at least some sort of relationship, even though the users had really no idea what was happening. In this case, these developers were plugging into the APIs, to the developer channels of the social networks, and then turning and selling subscriptions to social media surveillance software to law enforcement. In the wake of our report, and that was with the Center for Media Justice and Color of Change, these platforms shut down some of these services and imposed more restrictions on their APIs. And I think hundreds of police departments across the United States, from what I've heard, lost access to tools like Geophedia and Media Sonar. But it's every week now I hear from reporters or folks on the ground about new companies who are out there marketing their services as social media surveillance software tools like Media Sonar and like Geophedia. So the demand for these sorts of products is clearly out there. Whether or not they can get the sort of privileged access to the user data at the networks as they could before, it's unclear to me. I mean, I'm constantly, and our allies are constantly pushing on Facebook and Twitter to hire people to do auditing, to actually whitelist and check the sort of customers they're going to be granting access to their APIs. But there's a sort of another area of vulnerability that I think Facebook is having more trouble with and has done very little to counter in this context, and that is the sort of availability of public-facing information on the services. So Facebook requires as a default that certain information be public. Your profile photo, your name, certain information about your profile. There was a New York Times story about a month ago that said Facebook had suspended 2 Russian companies who had potentially been scraping that information using automated sort of processes. This doesn't require developer relationships. And they've been taking that information and using it to build out facial recognition databases. So there is still, as we understand it, pretty rampant scraping practices on these websites. They have teams who are looking for, repeat sort of pings from certain IP addresses, and they do have systems in place to prevent this sort of thing. But the scrapers are creative, and they know how to toss away IP addresses. They know how to use different servers to make the pings. And you have services out there right now who are marketing themselves as having significant amounts of social media data. And so, I mean, if folks are hearing, I do want to encourage folks, if you're hearing about products out there that I haven't mentioned today and that purport to have some sort of access to social media for law enforcement, you should contact the ACLU. You should let us know. We have constant lines of communication open with the social networks who still are not doing enough to protect their users, and we are placing pressure on them to actually take this seriously and hire people to watch these sorts of areas. And so, one final area I want to talk about, and Hanni is going to be the expert on this, is something that I've been hearing more and more about, which is that social media surveillance that is incident to arrest. So there has been an expansion of sort of probation and pretrial release conditions that require defendants open up their social media accounts and their electronic devices to on-demand searches by government agents and probation officers. I'm sure many of you have seen this in your own sort of probation agreements. We would encourage you, and Hanni, I think, is going to do the same, to challenge the hell out of these. We have time and time again seen probation conditions for electronic searches imposed in cases that do not involve electronic devices, and that maybe incidentally do, because all of us use electronic devices and services in our daily lives. Right now, there's a case before the California Supreme Court involving a search condition imposed on juvenile, which required complete access to their social media and their electronic devices for a crime that was not related to the actual search condition. And I've just heard more and more also that as pretrial release becomes more common, judges are also considering new conditions around access to these accounts and these services as well. And that puts the defendant obviously in a really weird place, because they're considering their liberty interest against disputing a sort of probation or a pretrial release condition that would allow the government very uninhibited access to their social media accounts and their electronic devices. So, I mean, defense attorneys can certainly play a role, and I look forward to hearing from more of you as you hear about these practices and the sort of new surveillance software products that are out there. I know a lot of you are already sitting down with your clients and not only explaining the sort of case file and the sort of considerations that your defendants need to know, but I'm sure it's becoming more and more common, and I've heard this from some defense attorneys, to actually have discussions about the state of this surveillance that exists out there that they may not know about on social media. The networks have not done, again, a great job of providing default privacy controls, providing explanations about these practices, and actually cutting down on these practices. And there's certainly a need for more resources. So, we look forward to hearing more about what folks here are doing to sort of talk to their clients about these issues, what you're seeing out there. But I think with that, we'll hand it off to Hanni. Thanks.
So I wanted to start by taking like a little bit of a survey of the room, and that is a couple questions. So number one is, how many attorneys here have gotten in discovery in a criminal case social media discovery, whether that's a Facebook or Instagram post or Twitter or whatever? So let me see a show of hands. Okay, so a lot of people. How many people in this room have seen in discovery in a criminal case information that law enforcement used one of these tools that Matt was talking about, like Beware or Geophedia, one of these social media monitoring tools? One person. And that's the problem. Because we know the cops have this stuff, and if they have it, they're going to use it, but when nobody sees it. And this is exactly the kind of problem that I want to talk to you guys about today, or one of the problems I want to talk to about today with this room, is that what we as the defense bar can do to learn more about these sorts of things. The other kind of piece I wanted to focus on is the probation and parole and the pretrial release blanket search conditions, because I think that's an important area where there needs to be litigation. And I can tell you from personal experience, and other AFPDs here in the Bay Area can tell you, we have very bad search condition language that's standard in our plea agreements here in the Northern District of California. And then the final thing I wanted to do is to actually talk about the flip side of this, which is defense access to social media materials from the companies, as well as companies like Google that maybe we don't think of them as a social media company, but have data that we want and that can be useful for us in our criminal cases, but we've got to jump through a lot of hoops and hurdles to get access to that stuff. So that's kind of the three general areas that I wanted to talk about. And obviously, Matt will jump in when he has something to say, and we'll keep all the questions to the end because I think we're going to have a lot of time for questions. So, number one, to start with, the idea that we know that law enforcement uses tools to monitor social media but doesn't disclose it. Obviously, if your law enforcement agency is using an informant or an undercover and communicating with your client to facilitate a drug sale or a firearm sale or whatever, you get that in discovery, and I've gotten that in discovery. Or, more likely is your client has a publicly accessible Instagram page where he posts all the prescription pills and firearms he has for sale, and then you get that in discovery too. And I'm sure everybody has had that case before, and myself included. But what we don't see is this more subversive surveillance that Matt was talking about. And it's not surprising. And we've seen these struggles time and time again when it comes to tools like this that the government doesn't want to reveal to the defense that they're using. So a couple years ago, it was all about stingrays, and we had lots of CLEs and presentations, and lawyers flew all around the country talking about stingrays and how the cops never wanted to own up to the fact that they had a stingray. And I'm just so we're all clear, stingray, these are like, another name for it is an IMSI catcher. This is like a fake cell phone tower sort of device. The cops can use it to kind of figure out a person's location. So for years, the cops were using it, but they weren't disclosing the fact they were using it, and they were calling it, an investigative tool, a source of information. They were kind of hiding the fact that they were using it. Because of efforts by the EFF and the ACLU and other organizations to learn more about how these tools were being used, the defense bar knows a ton of information about these tools. And we actually have case law from several courts across the country, including a district court here in Oakland, ruling on what the law requires for these kinds of devices. And it was only through digging and scraping little bits and pieces of data have we been able to actually learn anything about these kinds of tools. And now, I think if you go to a NACDL seminar and you talk to defense attorneys, a lot of them know what a stingray is. Or, in our office, our standard blanket discovery request that gets sent out in every single criminal case, whether it's a misdemeanor postal case or a felony capital murder case, the standard discovery request that gets sent out when our file gets opened makes a request for stingray, IMSI catcher, whatever you want to call it. This is common knowledge now. And even law enforcement, I think, to a certain extent, has kind of given up on trying to hide the fact that they use these devices, and they're more transparent about it. And in California specifically, because of changes to California's, the California Penal Code, they are now required to disclose more information about, when they use these devices and how often, because they're supposed to give a report to the state attorney general. So it took too long, it took too much litigation, and it took too much jumping through hoops and hurdles to learn about the use of that device. And I think we're going to go through the same exact struggle with these new tools that are geared around social media monitoring. Because again, what the government's going to say is, look, it's a source of information, or we honed in on a suspect and without revealing why. And the real problem with these tools is the government can use connections and links between people to try to bring guilt by association to other groups of people. So you heard about this, like witness intimidation, allegation. We see cases where, I haven't seen them in California, but I've heard about cases in New York where they'll do like a Facebook sweep and target people kind of who communicate with one another online and say, oh, here's a gang, this is a RICO gang sort of thing. So we know that they're using it, and we know that they're utilizing the links between people. So how do we get our hands and figure that out? Well, I think for people who practice here in the Ninth Circuit, there's good case law in the Ninth Circuit that talks about that, at least in federal court, that Rule 16 discovery is extremely broad. So if you're a federal practitioner, you need to be looking at Rule 16 and what it talks about, that the government has to disclose to the defense evidence that's material to the defense. And the Ninth Circuit has interpreted that to mean material that's needed to raise a pretrial motion to suppress. And so, how the government initiates an investigation is, I think that's a tricky issue to challenge under the Fourth Amendment, but we should need to start making and seeking discovery requests and trying to scrutinize, how is it that it's this person on this account that the cops are looking after. I can give you a specific example of a specific case. I had a case 2 years ago where the search warrant affidavit, my client was charged with being a felon in possession of a firearm. The search warrant affidavit, the first paragraph says, officers with the San Francisco Police Department were monitoring Instagram and came across my client's profile page. And unfortunately, my client posted a picture of himself holding a firearm. And somehow they were able to figure out, my client's a convicted felon. And, lo and behold, the cops are busting down his door and they find a gun. Well, why are they there to begin with? Is it because he's known to law enforcement? Is it because they keep tabs on him? Well, I don't really know. I couldn't figure that out. And I tried to figure that out, but I was unsuccessful. But I think that's an example of an area where we have to, as a defense community, start to be more aggressive in trying to figure out, well, why him? How is that the case? And when you have a search warrant affidavit that's based on that, then it becomes important because you're essentially challenging probable cause. How did they get here in the first place? What is the basis of the information that leads them to this guy to start this investigation? So that's one piece of this that I think that on-the-ground practitioners have to be thinking about is, how did they get to my client? Why are they here? Why are they looking at his Facebook page or his Instagram page or Twitter or whatever it is? So I think that's an important piece of it. The second thing I wanted to talk about was the probation parole search conditions. Like I said, here in the Northern District of California, the federal court, the standard plea agreement language says that every defendant who takes a plea agreement agrees that as a condition of their supervised release, which is like the parole period or probation period after you serve your sentence, that they're subject to a search of not only their car, their person, their home, but their electronic device and any and all accounts on that device, with or without a warrant, with or without probable cause, with or without reasonable suspicion, by any law enforcement officer, whether federal, state, local, you name it, at any time, at any day, for any reason. That is the standard plea language here in the district. Now, if your client has to take a plea deal because there's advantageous terms to it, that's how it goes, unfortunately. But if you have cases where your client's not taking a plea deal, or you've gone to trial and you came in second place, you gotta bring that challenge and say, not every criminal case is there a connection to a cell phone. This is something that Michael Price was talking about earlier this morning. The idea that probable cause to arrest or is not probable cause to search the phone. Everybody has a cell phone. So the idea that a cell phone is a instrumentality of a crime or a means by which crime is committed is ridiculous. And so we have to push back on that and challenge that in the right cases and put resistance when, the law enforcement's trying to say, well, your guy got charged with, selling drugs and drug dealers use phones. Yeah, well, everybody uses phone. My mom uses a phone. My grandma uses a phone. So, that's not, and they're not drug dealers as far as I know. So, that's got to be something that we've got to put resistance on and push back on, because otherwise we're opening a door to allowing this kind of pervasive social media monitoring, and there's no legal protection there. And I think one of the interesting arguments that's never really been fully explored, at least, I focus on the Ninth Circuit, and I don't know what other courts have said on this, but within the Ninth Circuit, there's never really been any question about whether that kind of condition is a voluntary condition for Fourth Amendment purposes. So, it's sort of kind of taken as given that if you sign a plea agreement and you've agreed to that condition, you've agreed to the terms of the agreement, you're stuck with it. And I guess that's the case. But if you have a situation where, you're accepting a grant of probation, in lieu of a prison sentence, does that mean you accept to all of those conditions? Do you have to object to that specific condition but agree to all the other terms of probation? That's something that, again, I can't say that I've surveyed all the case law throughout the country, but that's an area where there's some really interesting, I think, legal arguments to be made that, hey, just because I agreed to take probation doesn't mean I agree to every single piece of it that comes along the way. And I'd point out that the courts have said, including the Supreme Court has said, that there has to be a difference between what people on pretrial release and people on probation and people on parole have different Fourth Amendment rights. So somebody on parole is going to have the least amount of Fourth Amendment rights. Somebody on pretrial release who hasn't been convicted has more Fourth Amendment rights than a parolee. And that difference has to mean something in terms of what conditions are going to be deemed acceptable. The idea that every person who comes through the criminal justice system, whether they're pretrial, a probationer, or a parolee, is subject to the same blanket search condition, that is incorrect under Fourth Amendment doctrine if you're applying it really strictly. And I think that's another area where there's room to be made in litigating it. And then the final thing I wanted to talk about before I open it up for questions, or if Matt wants to jump in, is how we as the defense community can get access to this data. So again, I'm going to take a survey here. How many attorneys here have successfully gotten, through subpoena or consent, records from Facebook, Twitter, Google, LinkedIn, whatever? Anybody? Okay, how many people have tried? Okay, so more people have tried than have been successful. And I think this is another area where there is room to litigate and room to bring challenges. And I want to start by talking about kind of the statutory framework that applies, that the social media companies and providers use to say we don't have to turn over anything, because I think this is the obstacle that myself included have encountered when we're trying to get information. So I'm sure if you've sent a subpoena to Facebook, for example, you've gotten back a stock response that says Facebook is disclosed from turning over social media information under the Stored Communications Act, which is in Title 18 of the Federal Code, sections 2701 and so forth. And what the Stored Communications Act says is that providers of what are called electronic computing services, I think I have that right, and remote computing services, and these are archaic terms and we don't need to waste too much time dissecting what those terms mean, but people who provide electronic communication services online are prohibited from turning over information, and actually, to be clear about it, from the contents of communication over to the public or anybody. That's kind of the general starting point of federal law. Then the next section, of course, because as it's a federal law, has all the exceptions. And all the exceptions are for basically, law enforcement, the cops, the FBI, any law enforcement agency can get it. Sure, no problem. But don't you dare, defense attorney, try to get your hands on this stuff because we're not going to give it to you. And so that's the blanket response. And I bet for those of you who have tried to get information and have been unsuccessful at getting information, that's been the response you've been given. Facebook or Twitter, whoever it is, will say, the Stored Communications Act prohibits us from turning over this information, unless you're a cop, in which case we have this whole fancy website for you to go in and get your stuff without any problem. So what is our response to that going to be? Well, beyond, throwing up your hands and cursing out the walls of your office, I think, number one, we have to be very clear that there is a distinction under federal law between the contents of communication and everything else that the companies have. So, contents of communication, that's like a Facebook post, okay? I go on Facebook and I write, I'm going to the Berkeley NACDL conference today. That's a post, that's the content of a communication. And that's what the law prohibits the providers from producing. Now, there's a lot of other stuff that the companies have that is not the content of communication, like my username and my profile account information. Any other kind of what we call metadata associated with my account is not the content of communication in most instances. I think you can get into some gray area, but for the most part, in my view, that's not the content of communications. So when the companies put up a blanket no, that is not correct. There has to be a distinction between the content of communications and everything else. Now, of course, I know what you're thinking. Well, I don't really care about all that other stuff. What I really want is the wall post that shows my guy got entrapped into selling drugs or got propositioned by this person and he didn't have predisposition or whatever it is. So how do we get the posts? And I think this is where there has to be litigation and challenges raised under the Sixth Amendment right to a defense that have to be raised to say it's an uneven playing field that allows government access to information and prohibits defense access to information. And what I can tell you is, there was a case in the California Supreme Court that was decided earlier this year that had teed this issue up. And then the California Supreme Court totally punted on it and was like, we're not wading into the Sixth Amendment piece of it. It's too complicated. And there's like federal preemption and all this other stuff. But in essence, this is an open issue that, in my view, has been under litigated, and by myself included, because a lot of times the tendency is to just throw up our hands and say, well, it's too hard to get this stuff. The other thing I would note is that, in my experience, the companies are very poor and not equipped to deal with defense attorney requests for this data. I'll give you a specific example from a case that I've been working on. I had a case where I wanted to get my clients' data from Google. I wanted to get it from the company directly because I'm thinking like a trial lawyer. I want it to be a business record so I can get around the hearsay rules. And I wanted a certification from the company so that I could get around authentication. In other words, if I get the records from Google, then they are business records of Google, and they are self-authenticated by Google, then I can admit them into evidence. And so I'm trying to think, how can I backdoor in my client's statements into evidence without putting them on the stand? Now, maybe I'm overthinking it, maybe I'm still have a hearsay problem because there's multiple layers, but at least that was my goal. So I contacted Google and I said, I have a signed consent form from my client. My client is not able to access a computer because, he's incarcerated. So, I have a signed, notarized consent from my client to give the data. Google's response was, we can't do that. I said, why not? I said, the only way we can do it is through the takeout process, where we send an email to the user, and that user logs in and sends an email confirming that he consents to disclosure. I said, well, that's not possible. My client's in jail. They said, well, you can log in, and your investigator can log in and do it. Now, that kind of begged the question, well, that's not really very good privacy protection if any person who can hack into the account can give access to Google, and that's literally what their legal representative is telling me to do. But putting that aside and the ethical issues and the legal issues with doing that, they said, well, we have an alternative. And I said, well, what's your alternative? They said, well, you can get a court order where you get the judge rules that the consent your client has given is sufficient, and then we will produce the records. And I said, okay, do you have a template you want me to use? And they said, yes. And they sent me the template. And the template is styled in a civil case. They know I'm a criminal defense attorney. It says this is a consent form agreed to by the parties. In other words, they sent me a template that showed in a civil case where the plaintiff and the defendant both agreed that the user could consent to the disclosure of data, submit it to the judge, and then produce it. Now, if you're a defense attorney, you're thinking, well, I don't think I'm going to call the DA and ask if they consent to the disclosure of my client's data, or, even more critical, some third-party witness that they don't even know about who's going to be blow up their whole case, right? So this is an inadequate way to deal with it, but this is the mechanism that, again, only it's my experience, and I don't want to presume that that's everyone's experience, but this is a conversation I had with Google a month ago about how to get access to data that my client's data for which he is willing to give me access to and has a signed, written, notarized consent form. So clearly this mechanism, these procedures are inadequate. And it shouldn't be that the cops get a whole portal to data that nobody else can access. And so I think, again, this is an area where there has to be pushback from the defense bar and pushback to ensure that our clients are getting, Sixth Amendment sufficient representation and getting access to material that can further their defense. And again, this is where if you're a federal practitioner in the Ninth Circuit, the Ninth Circuit has good case law on this that says, relevant to the defense includes not just relevant to a trial defense, but relevant to a pretrial motion. So if you want to raise like a Franks issue and the credibility of the complainant or the affiant is important, that's going to be something where you're going to want to get information, and perhaps there's potentially useful information in the social media accounts. We got to push back and seek that. So that's kind of my spiel on that, and again, I can understand that maybe I'm just venting from my own negative experience with Google, but I mean, I suspect that that's an experience that other people in the room who've tried to get records and try to get information from the companies have had. And I understand, I get where the companies are coming from. They're trying to figure out, well, how do we safeguard, all these users' information? How do we keep it private? And there has to be some sort of balance between keeping information private, but also allowing a defendant to exercise their Sixth Amendment right. And I think that's an area it's always sort of, in my view, kind of been percolating and talked about. It's not really been fully litigated. I understand it can be challenging to litigate that. Oftentimes, we don't want the social media data because it's bad for us. But in those rare instances where it's good, where there's something exculpatory in there, where there's something that would be useful to your case, even if it's for like sentencing mitigation. And when you have you want to be able to we should have some sort of mechanism to get access to it, at least with some sort of judicial oversight. So that's my spiel on that. And unless Matt wants to jump in, I did want to leave time for questions. We have about 15 minutes. So I did want to make sure we had time to take any questions that people have about anything that we talked about. So I'm gonna open it up for questions. Again, unless you want to jump in with anything. So the question was whether the police searches without a warrant violate the Wiretap Act. So I mean, I think there are a couple things at play. So, and this is something that the Supreme Court kind of talked about in Riley. It wasn't an issue in Riley, but it was kind of percolating. So, your phone has the Facebook app on it, okay? Now, your phone may store data from that, from your Facebook app on the phone. But really what your phone is doing is communicating with Facebook's servers, right? And getting access to the photos and the wall posts and all that stuff. So, if the cops are in the phone and they open up your Facebook and they start communicating, without consent from the client and without a warrant and without a wiretap order, I mean, there's a real tricky issue there. And there's actually a Washington State Supreme Court case on that kind of scenario where the cops arrested a guy, took his phone, this is pre-Riley, they took his phone and started texting with another guy to set up a drug deal and then went and arrested that guy. And the Washington State Supreme Court said that was a violation of Washington State statute, the Wiretap Act, and the Washington State Constitution. Now that's a state court decision, so we don't get the benefit of it in California. But those sorts of things have come up from time to time. And if you have a scenario where the cops are communicating in real time and there's no court order, then you've got a real potential wiretap issue and a warrant problem. I haven't seen it come up, I focus on California Ninth Circuit stuff, so I haven't seen it come up in this district all that often or in the Ninth Circuit, but I mean, I think that's something that we have to be thinking about. And I think another piece, and to go, again, to speak into something that Michael said earlier, even if you have a scenario where the cops get a warrant for Facebook data, I think it's the same sort of issue, pushing back and saying, hey, just because a person commits a crime doesn't mean that that there's probable cause to get the Facebook data. Again, there has to be a tie between the crime and the data they want to show the probable cause link, and all of the particularity issues and concerns with like searching a computer or a person's cell phone, I think apply equally in the social media context. Facebook has all sorts of crap that, people post on it. And the idea that, well, my guy is charged with a crime, thus he must have communicated about the crime on Facebook, thus the cops get access to his entire Facebook account. I don't think that's correct under Fourth Amendment law, but that's never really been pushed, I think, that hard. I think we're still I don't want to say we're at the beginning of this kind of battle, because I think that, there's been social media evidence in criminal cases for a decade, but I think, lawyers are becoming more assertive and creative, and I think the courts are becoming a little more receptive after both Riley and Carpenter that, hey, the courts may actually take serious this idea that, hey, digital is a little bit different, and that there is too much stuff stored online in an electronic format to just let the cops have willy-nilly access to it without any limitations.
In the case I talked about before the California Supreme Court, the case challenging the juvenile search condition for probation, EFF and us in our brief, we drew an analogy to the Wiretap Act, basically arguing that, not that the Wiretap Act was violated on its terms, but that allowing the government to have on-demand prospective access to somebody's online accounts, where they could call them in at any time to see information that at the time of the agreement has not been created yet, is akin to a sort of a functional wiretap. It allows the government to come in and see continued communications, to see conversations that have not been created at the time of the plea agreement. So, I mean, it's sort of an analogy that folks should use, and we thought worked in a sort of challenge in reminding the courts that the probation condition was, failed this at least this California standard of a reasonable relation to the crime that the person's been charged with.
Yeah. So the question was, what, if any, experience has there been trying to get these companies to respond to requests or subpoenas issued from outside of California and outside of the federal court system? And, I haven't had any experience with that. So I don't know if I'm the right person to answer that question. What I think one of the advantages the companies have, in addition to geography, is that they have these humongous, sophisticated legal departments, and the giant law firms are backing them, and then you're like a public defender or solo practitioner, you've got a million cases, you've got a million things to do, and it's a challenge. And so I don't have a great answer for your question, and I don't have specific anecdotes. What I can say is, again, I have seen in a California state court a case, a criminal case. This is different than the case that ended up in the California Supreme Court, but I have seen a case where in Yolo County, which is a pretty rural county just west of Sacramento County, where Facebook showed up in court and basically said, we don't want to provide the records, and the judge was like, I don't care, you're providing the records, and then it kind of got worked out in the end. But I mean, I think one avenue is, again, in federal court, and I'm sorry to keep coming back to my experience because you're not asking about about that, but what I can say is, in federal court, we can't just issue a subpoena, right? We have to get a court order to issue a subpoena. And I think to the extent you have judges who are sympathetic, at least to the idea that there has to be a level playing field, or that you can, or in situations where you can make a showing to the judge ex parte and under seal, like, look, judge, this is not a fishing expedition. I've got a real basis for seeking this kind of information. And getting the judge involved, I think the companies are way more responsive to a court order or a subpoena that is that is the result of a court order than just a lowly public defender subpoena that, like a trial subpoena that we would issue just from the clerk's office. And so to the extent you can get your judges involved, I think that will help. To the extent that you can make do your homework ahead of time and be ready to respond when they come back with a blanket, we're not turning it over, and then you can say, well, actually the law says blah, 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 and the case says blah, 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 I think they may take you a little more seriously. And, I think that, the more pushback there is, hopefully the more responsive the companies will be at responding to those requests, or at least recognizing that they can't just be so completely dismissive of it. I mean, this is a problem that there's a law review article written, from like in 2007 talking about this issue and talking about how it's an unlevel playing field. And here we are in 2018 and it's the same problem. And the only people who get disadvantaged by the framework unsurprisingly, is a criminal defendant, right? Everybody else, the public gets privacy, the government gets access to it, but if you want it, for your client to save their life and protect their liberty interests, too bad. And so I think there has to be resistance, there has to be court intervention, there has to be constitutionalization, to make up a word, of those kinds of challenges to say, enough is enough. Or to at least put the courts in a position where they're going to have to actually confront this tension instead of ducking it because of the statutory framework. I mean, the bottom line, one of the big major takeaways from Carpenter, in addition to it, saying the Fourth Amendment protects, cell site records, is, the Supreme Court said part of the Stored Communications Act is unconstitutional, right? They said part of the statute is unconstitutional. We have to start every single request and every single motion with, the Supreme Court has said this statute is unconstitutional. And they were talking about it in the Fourth Amendment, but it's unconstitutional under the Sixth Amendment too, to the extent that it prohibits disclosure of information to the defense when a showing has been made. And in all sorts of other scenarios do the courts strike a balance between the privacy interests of the public and the defendant's right to access data and subpoena information useful to their defense. But why is it in this one area, which happens to be the area that everybody, that for which there's data for every single person in a universe, this is the one area where we're drawing the line. And I think that's not right. And so, rant over it, but. Right, so to repeat the question, the Hunter case, which is the state Supreme Court case about Facebook access records, it punted on the constitutional issue, but what it did say was, the Stored Communications Act does not prohibit a social media company, from producing publicly available information that is still publicly available. I think I have that right, because it's a long, confusing opinion. So the question was, how do we use that to our advantage as defense attorneys? And I think, again, just like I would say, if you're filing a constitutional challenge, you lead with the Supreme Court said the statute's unconstitutional. I think you lead with California Supreme Court said the statute on its face allows me to have public access to information. So this falls out of the rubric of the prohibition under the Stored Communications Act, and thus I'm entitled to have it. And I don't have to make any other showing. The California State Supreme Court said that's the case. And then you also make your Sixth Amendment argument too, because again, you have a right to a defense. So I mean, I think again, the Hunter case is still pending in the Superior Court down in San Francisco, and so there's going to be more litigation to come out of that. But I think the other thing to point out in the Hunter case is, if I recall correctly, Facebook conceded that point in the state Supreme Court. So, I think that we have to say that, hey, you guys yourselves said this is a permissible basis to get these records, so, we're holding you to what you said in the courts. And we're entitled to it, at least to the extent we're talking about publicly available postings that are still publicly available. I mean, once you start to get into the more private stuff, of course it gets a little trickier, and that's where I think you're going to have to make a constitutional challenge. But, again, I mean, I think this is an area where the law is not bad yet, so we should probably try to go out there and make good law, or make bad law too, maybe, but that's how it goes, and there is room to challenge that and raise complaints about that standard. Yeah, I mean, I think the answer to that is yes. Now, how do we get there legally? That's for you guys to figure out. But I mean, I think that the bottom line is that between both Carpenter and Riley, we have 2 Supreme Court cases in 4 years that recognize digital is different, and that there is a growing recognition from a very conservative court that people's lives are digital and electronic and online, and to the extent that we can make constitutional challenges that focus on that growing recognition, we should be doing that. And so
state constitutional challenges too. So we have Article 1, Section 1 here in California. One of the keystone cases of Article 1, Section 1 is White v. Davis, where law enforcement places an informant inside of a classroom, and the California Supreme Court finds that violates the sort of right to privacy that voters put into the law, into the Constitution here in 1974. So I mean, Article 1, Section 1 litigation has gone in various directions in the past 20 years. But I mean, I think the sort of quality and quantity of information about people is getting to the point where you can paint a detailed picture of a person's life with an undercover officer on a Facebook account, clearly. You can do it across time and across geography. So that area is also ripe.
And I would add one thing to that, and this goes to something Matt said earlier. There's pretty bad Supreme Court cases from the 70s and 80s that talk about like cops can rely like on a bulletin about a suspect that gives them, if it's reliable, that could be the basis of like reasonable suspicion for a Terry stop. But what the issue comes down to then is the reliability of the data. So if you've got cops purchasing bad data, then we should have a right to challenge the reliability of that data, which in turn speaks to the reliability, or not the reliability of, but whether there's actually reasonable suspicion or probable cause for a stop or an arrest or whatever. And there's actually a very good 10th Circuit opinion written by Gorsuch on this. I forgot the case, I could get it to you afterwards, but where he basically, it was a case where, it's a pretty simple set of facts. It's like there's a highway patrol officer driving on the freeway. He sees in Kansas, he sees a car with a Colorado temporary license plate, and he sees the driver is acting suspicious because he's wearing his seatbelt and driving with his hands straight. And he happens to be Hispanic in Kansas. So the trooper calls into dispatch to say, hey, run the plate. So they run the plate and it comes back, there's no hit on the tag. But, and this is the critical fact, the dispatcher said, but Colorado temporary tags don't always show up in the registration database. So the cop decides to pull the guy over and, make a long story short, the guy's a defendant in a meth case in federal court. And essentially, he files a motion to suppress saying there's no basis to stop me. There was no traffic violation. The only reason he got stopped was because of the tag. And so the district court denied the motion to suppress, but the 10th Circuit reversed and said the issue came down, and this is a Gorsuch opinion, the issue came down to the fact that the stop was based on inaccurate, incomplete information that the dispatcher provided to the patrol officer. So you need to have a new evidentiary hearing to determine what is the reliability of the database and whether it was sufficient to rely on that for reasonable suspicion to do the Terry stop. That's exactly what we're talking about here. If you have a bunch of broker data and it's junk and it's pulling up inaccurate information, we need to have an ability to challenge that because that speaks to whether the Terry stop is good or whether the probable cause arrest or stop is good and all that. And so I think that's, you bring a great point in terms of, another avenue to think about ways where we can chip at this and challenge it. They gave us the 1 minute sign, so I guess that means our time is up. But we'll stick around and answer any questions anybody has. So thank you.
Everyone.